It's been a month since I've done it, so
Here are the steps we do.
yeah. Yeah.
Oh, it's there now. This wouldn't show up.
So now, yeah,
Yeah.
no. Wait a minute. Just click off that, get rid of that.
Yeah, that's what I do. The problem is I couldn't get to that
So now you're
screen.
good.
All right. All right, let me bring everybody back.
In the rain. Store.
Luke, I lost the contact visiting room. I shut my system down for a minute, so I'm gonna need him back in. Thanks. Bring it. All right, we have the live feed now. We haven't started recording yet. We had to make doubly sure the chat was turned off. We'd had some glitches here recently. They're bringing the defendant back from the jail. I shut that channel off. So give me one moment. Well, I don't know what's doing where you are, but it's pouring rain here. Let me bring the defendant in. Good afternoon once again, Mr. Dingman. I'll leave it up to you. You can take your mask off or leave it on. And Kylie, I'm going to mute your microphone. All right, Laura, let's go on the record. This is the time and date for the continued preliminary examination in the matter of People versus Ethan Nicholas Dingman. Mr. Dingman is connected here with us. We are on the Zoom platform. We are streaming on YouTube. Also present is Special Prosecuting Attorney Amy Shepard and counsel for the defendant, Mr. William Weesey. Also present is the officer in charge of this case, Chief Martin Brinkert from the Colon Police Department. We continue this matter from last Tuesday afternoon, June 1st, until today. The court gave an opportunity for the prosecution to present any additional evidence if they wished. So let me tell you who's in the waiting room. I have Donald P., who's from the crime lab. I have Jatendra, I don't know who that is. I have Kevin's phone, and I have Michelle Schmidt.
Mr. Donald and Ms. Schmidt are the two witnesses that we would be presenting from the crime lab. I am not positive, but I believe the rest of the people might be family participating who are not present, in addition to the ones who are not present in the courtroom.
Well, they also may be just in the wrong courtroom, so let's find out who Jatendra is. Good morning, sir. What case are you here for?
Okay.
I see a lot of ceiling fans. Sir, what case are you here for?
Yes,
What's your name?
Jitendra Patel.
Why are you here?
There is a lawyer office call me and she send me a ID, Zoom ID number to connect the meeting.
Well, this is a middle of a murder preliminary examination, so I'm not sure what it is, but it isn't this. So,
Sorry, sir. The
uh,
guy name is Reggie King, and
oh,
they
Reggie
need,
King. All right,
yeah,
okay, I got it. All right, let me tell you to call this number. Do you have something to write on?
yeah.
All right, file number is 445-049-81.
Just a second, sir. Just a second. 445
049
049.
8188.
So I have to call this number.
Correct.
Okay, I'll call.
All right, thank you. That's not your fault. We moved some things around. So
Oh, okay.
call that number and they'll be waiting for you there.
Okay, no problem, sir.
All right. What had happened is I had traded some things with Judge Pattison to open up this afternoon. So some witnesses, as you saw, got a notice to contact this court. They weren't doing anything wrong. We had just not updated them. So, all right, I think we're where we need to be now. Although we don't know who Kevin's phone is. Every day it's a struggle to get all our waterfowl in a row to. Do you guys know who this is? Kevin's iPhone, who am I speaking with?
Deputy Penn. Sorry, we don't
All
have
right.
power, so I don't have internet. Not sure if this is going to work or not.
All right, which case are you calling in for, Kevin?
Reggie King.
All right, I'll tell you the same thing I told the last people. It's been moved over to Judge Pattison's courtroom. You got a pen?
I can try and find one.
Crayon?
Yep, go ahead.
Magic marker? Quill pen? All right, the number is 445-049-8188. It's been moved over to Judge Pattison's court.
Okay, is that the Zoom ID then?
Yes, it is.
Perfect, thank you much.
All right, thank you. All right, I'm sorry. I think we've got what we need. At any rate, this is the time and date for the continued preliminary examination in this case. The court gave the opportunity for the prosecution to present any additional evidence if they wished. The matter was continued till this time and date. Ms. Shepard, do you wish to produce any additional evidence?
Yes, Your Honor. The people intend to call two witnesses. That would be Paul Donald and Michelle Schmidt, both from the Michigan State Police Forensic Laboratory in Grand Rapids. Additionally, we have one more report that we would submit to the court pursuant to MCL 766.11B1D. I did email mid-morning Mr. Weesey about this to see if he had any objections or if we could stipulate so I could send it to the court ahead of time. However, I believe he was otherwise occupied and did not get to see that email until right before we came into court. And so I would be moving to admit that at the end of the testimony of these other two witnesses. But I'm just making the court aware of that at this time.
All right, thank you. All right, who do you wish to call first?
We will call Paul Donald.
you want me to clue Michelle Schmidt in as to what we're doing?
I told her yes to Friday, how we would be proceeding, so she was aware that Mr. Donald would be testifying before her.
All right. Good afternoon, sir. Are
Hello.
you Paul?
Yes, sir.
Would you raise your right hand, please? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Would you state your name and spell your first and last name, please?
Paul Donald. Paul-Donald.
Thank you, Mr. Donald. Prosecutor Amy Shepard has questions for you, and then Defense Counsel Mr. William Weesey will have some questions for you as well. Madam Prosecutor?
Thank you, Your Honor. Mr. Donald, where do you work?
I work at the Michigan State Police Crime Lab, which is located in Grand Rapids.
And what do you do there?
I perform forensic biology.
Now, in your capacity as performing forensic biology for the crime lab, are part of your responsibilities examining evidence for the potential for DNA analysis? All right, and I'm sorry, I couldn't hear that. Could you state your answer again?
Yes.
Thank you. And is there a standard procedure that you follow in performing this type of inspection?
Absolutely.
And what's that standard procedure?
Well, when given items like articles of clothing, the procedure starts with a visual examination of the items in order to determine if there are any plainly visible stains on the items. And then after a cursory visual examination of the evidence, then the items can be subjected to an alternate light source if necessary in order to enhance any stains that may or may not be visible under just normal visible light conditions. And then once any particularly interesting stains are identified, then move on to a presumptive screening tests that can be used to determine whether or not the stains can be, like, for instance, a reddish brown stain could be a blood stain, or if a stain that's not visible with the naked eye that lights up with the alternate light source, that could be tested for possibly semen or saliva. And then once any particular stains of interest are identified, then a sample of those areas of interest are collected and stored in a sterile environment until they can be processed with DNA analysis.
In terms of the presumptive screenings, are you familiar with something called hemosticks?
Yes.
And is that something that you use for in performing these presumptive screenings?
Yes.
And can you describe for the court what hemosticks is and how you use it?
First, could you spell it for the reporter?
Absolutely. Hemosticks is
We're
spelled-
losing we're losing your microphone. You're in and out a little bit.
Hemosticks is spelled Hemastix, and it's a trademarked item that's available predominantly for use in the testing for blood, like for people who might have diabetes can use these test strips to check their urine for blood. So they're very sensitive for blood, and they're very sensitive for some. They will react with other things too. So it's not very specific, but it's very sensitive. So we use them to test for the possibility of blood, and so it's a color test, and an unused hemostix is yellow, and when it comes in contact with blood, it turns a dark green. So it's very clear if possibly blood has touched the hemostix. So we would call that a positive result.
Now, you indicated that after performing a visual observation, as well as potentially if you have to do any other observations, like with an alternative light source, and performing these presumptive screenings, that you collect samples. How do you go about collecting those samples?
On the item of evidence, either a sterile swab can be used to collect a stain, or an actual cut of the item that the blood stain is on can be taken from the item in order to be forwarded to DNA for analysis.
Is there a reason why you might choose to swab something or to cut something rather than the other?
So, like for instance, a hard non-porous surface would definitely be easier to take a swab of that item. And then for items like clothing, clothing offers more of a possibility for a mixture of future DNA analysis, because you might get DNA that was imparted on the item prior to the event in question, or like DNA from the person that was wearing the clothing. So depending on the nature of the sample that's being collected, sometimes it might be better to actually take a swab of an area of clothing that might have a blood stain on it, as opposed to a cut of that item, in order to kind of reduce the possibility of a DNA mixture future down the road.
Now, in the course of your employment with the Michigan State Police Forensic Laboratory, did you assist with the investigation in a case involving a suspect of Ethan Dingman and the victim of Todd Schwartz?
Yes.
And in fact, did you respond to the scene initially in this case in order to assist?
I don't recall.
Okay, but following that, did you have the opportunity to inspect some items that had been collected into evidence to determine whether or not they may be suitable for DNA analysis? And following this investigation or this process, did you author a report summarizing your findings? And I'm sorry, you're breaking out again. Was that a yes?
Yes.
I'm going to show you on the screen share what's already been admitted into evidence as People's Exhibit 13. Oops. Do you see the item on your screen?
Yes.
Do you recognize this document? If you need to see more, that's okay.
Yes, it looks familiar, and I see my signature at the bottom of the report at the signature block area.
So is this the report that you authored summarizing your examination of the various pieces of evidence?
Yes.
All right. So I'd just like to go through a few of these pieces of evidence with you. Starting with what's been labeled in your report as GR19-7142-1. Those items on your report are indicated as shoes. Did you examine those shoes for the possibility of DNA, or for suitability for DNA analysis?
Yes.
And how did you go about doing that?
Well, like I said before, starting with the visual examination, and there were reddish brown stains readily visible on these shoes, and there were reddish brown stains noted on the tops of both shoes, on the side of the shoes, and on the bottom of the right shoe.
After observing this, did you also perform a presumptive screening?
Yes.
And how did you do that?
I selected two areas of the right shoe, and one from the top and one from the bottom, and they were both positive for the possible presence of blood.
Now, did you go about performing or collecting a sample for possible DNA analysis?
Yes.
And how did you do that for the shoes?
That involves just taking a sterile swab and you moisten it with a little bit of sterile water, and then you just rub gently on the reddish brown stain that's been identified as possibly blood. And then it's dried, and then a portion of the swab that lifted the blood stain is cut away from the swab and placed in a sterile microcentrifuge tube, and then it's placed in frozen storage until it can be processed in the future for DNA analysis.
And why did you decide to go with a swab in this instance as opposed to a cutting of the shoe?
Well, shoes are a thick, porous surface that can be difficult to cut. So, like my example earlier with hard surfaces, it's more convenient to take a swab of the stained area. And in addition, if you're taking a cut of that shoe, you may be getting layers of years worth of other stuff that's been imparted on the shoe prior to the event in question, whereas a sterile swab lightly rubbed on the top of that affected area will likely just focus on picking up the most recent event that imparted the reddish brown stain on the shoe, as opposed to the history of the shoe.
And when you're worried about other stuff, do you mean also potentially other DNA contributors?
Absolutely.
Moving on to DR19-7142-3, and your report indicates that those are pants. However, there's two different pants listed on the report, specifically regarding GR19-7142-3. Which pants are those?
They're a pair of, I'm guessing nylon sport pants.
And when you say you're guessing, do you mean as to like the material that makes up the pants?
Correct.
And did you find that it might be provide the potential for analysis for the presence of DNA?
Yes.
And how did you determine that?
Well, there were some reddish brown stains that were visible under normal lighting, and then with the aid of an alternate light source, there were several smaller stains that were also noted on the pants.
And so then did you perform a presumptive test on them as well?
Yes.
And was that positive?
Yes.
And did you end up taking a sample for the purposes of potential DNA analysis?
Yes.
And was it a swab this time as well?
Yes.
Moving on to GR19-7142-7, items listed in your report as glasses. How did you evaluate those?
First of all, after taking the glasses out of the sealed package that it was submitted to the laboratory, and there was just a cursory visual examination of the item, and on the glasses there were 4 reddish brown stains that were readily noted on the glasses.
And did you also do a presumptive test on those stains as well?
Yes.
And was it positive?
Yes.
And did you take a sample for testing purposes?
Actually, 2 samples were taken from the glasses.
Okay. And were those samples swabs again?
Yes.
Moving on to GR19-7142-8, listed as a shirt. Do you remember how the shirt appeared, what color it was?
Yes, it was a light gray shirt and had some writing on the front of it.
Just a minute. I'm not seeing a 19. Evidence received, 1 through 12.
And I think I misspoke. Let me try again.
Because there's 2 shirts.
Yes. And so in regards to GR, I'm doing this right. GR 19-71428. Is that the item listed as a shirt in your report?
Yes.
And then GR 17-71429 is listed as a sweatshirt?
Yes.
All right. In regards to the shirt, what color is the shirt?
I believe it was a gray t-shirt. Had some writing on the front of it.
All right. And in regards to the sweatshirt?
Color of the sweatshirt.
Yes.
That was hard to tell. The sweatshirt was essentially soaked in blood, and it was putrid. I didn't make a note of color of the sweatshirt.
Okay. All right. And in regards to that T-shirt, the GR 19-7142-8, did you what did you do to see whether or not it would be suitable for DNA analysis?
Just the presumptive test with the hemosticks as before.
And was that positive?
Yes.
And did you take samples for testing?
Yes.
And how did you do those?
With a sterile swab and just moistened with sterile water, like I said before, and then lightly rubbed on the blood stain that was on the shirt.
Now, moving on to item GR 19-7142-10D, was that a listed or a submitted buccal swab from the suspect in this case?
You're asking about item 10D?
Yes.
Okay.
I don't have a 10D, I have a 10.
I think if you scroll, or if you go down to the second page of the report, the very last item on page 2.
Okay.
And I think to clarify that, Mr. Donald, in Michigan State Laboratory reports, if a lab number is followed by the letter lowercase d, what does that mean?
That's a sample of an item. So the D just signifies or denotes a derivative sample that was taken from a larger evidence item. So in this case, the item would have been identified as 10, and then the sample that's taken from item 10, we add a little d in order to signify that that sample was taken and forwarded to DNA for DNA analysis.
And is that what happened in this case with the buccal swab from Ethan Dingman?
Yes.
And finally, moving on to item GR 19-7142-12, listed as fingernails. Did you attempt to do anything to see if they were suitable for DNA analysis?
Yes. So with regard to the fingernails, I guess the goal with regard to something like a victim's fingernails is to try to determine if their hands came into contact with anything, and during the event in question. And so, like in situations like this where there may or may not be reddish brown stains on fingernails, when I'm collecting a sample from the fingernails, if there's reddish brown stains, it's safe to assume that those large reddish brown stains could be attributed to the victim. So I would focus to areas that don't have reddish brown stains in case there's the opportunity to possibly collect microscopic amounts of contact or transfer DNA that might be stuck underneath the fingernails.
And is that something that you did in this case?
Yes.
And how is it that you take a sample from the areas that wouldn't have any staining on it?
Well, just like I explained before, with taking a sterile swab that's moistened with sterile water, and then and again focusing on those areas away from the reddish brown stains to try to get a sample of any potential DNA that might have been imparted onto the fingernails.
And when you testified in regards to the sample taken from the shoes, you also testified to the process of preserving the items for ultimately being analyzed for potential DNA analysis. Was that the same thing you did with the rest of the samples, the items we've just discussed?
Absolutely.
Thank you, Mr. Donald. I don't have any further questions from you at this moment, but Mr. Weesey may.
Mr. Weesey?
No questions, Your Honor. Thank you.
I have a couple. Could we show the items to the witness, the photographs?
Yes. This has been admitted into into evidence as People's Exhibit 3. It would help if I shared my screen.
All right, stop. There's a pair of shoes, and I can't tell if that's the color they are or there's something on them. Are you saying those shoes I'm looking at are blood soaked on the top?
Well, I certainly wouldn't say they were soaked in blood, but there definitely were reddish brown stains on those shoes and on the bottom of the right shoe.
All right, but is that color of the shoe is not blood color, it's just you're saying there's some stains of blood on the shoes?
Yes.
The laces of the right shoe look dirtier than the laces of the left shoe. Is that blood on there?
My notes don't indicate that reddish brown stains were noticed on the dirty laces. It was just on the top of the shoe, the actual shoe, on the side of the shoes, and on the bottom of the right shoe.
All right, go ahead. All right, there's a little red mark on the bottom of the right shoe. Is that what you're talking about?
Yes. Near the circle area.
Near the circle area, I don't see that. I see a horizontal red thing in the middle of the shoe on the instep. Is that what you're talking about?
My notes indicate in the pattern of the circle on the bottom of the right shoe was where a reddish brown stain was noted.
All right, we can't see that very well, but the shoes don't appear to be blood soaked on the bottom or anything, do they?
No.
All right, thank you. Next. So that red thing we're seeing in the middle of the shoe is not relevant?
Not in the arch area. That's just soil.
Okay. Thank you, that's helpful. All right, next. And those are consistent with the glasses you examined?
Yes, sir.
Next, which would be Exhibit 9, a close-up of the glasses. All right, next. And those are consistent with the nylon pants you examined?
Yes, sir.
Where were the stains there?
As I recall, the larger stains were near the kind of like just above the knee area, and then the smaller stains were found near the cuff of both of the pant legs.
So there's a big stain right in the middle of the front, near the waistband. Those are not blood?
No, sir.
So there's a couple of stains we can't see in this picture, but you could see them either there or with alternate light.
Correct.
All right, the next one. You testified to a blood-soaked sweatshirt, and so at this point, I've heard no testimony about any blood-soaked sweatshirt, blood-soaked or otherwise. This is exhibit number 11. It appears to be a plaid lined flannel type shirt. Did you examine this?
I'm not sure. I have my item 11 as a reference sample.
All right. Next. These aren't really relevant. You mentioned a T-shirt with writing on it. There was some discrepancy between what the deputy testified to and what was in the lab report, but I don't have any evidence of a blood-soaked sweatshirt. Which would be item 9 on your exhibit on the report. All right, Mr. Weese, does that raise any questions for you?
No, Your Honor, thank you.
All right, anything further, Madam Prosecutor?
Very briefly, Mr. Donald, in regards to item number 9, your report does not indicate that you took any swabs from that for the purposes of DNA testing. Why is that the case?
Well, since the item was soaked in blood, and I recall it may have been the victim's sweatshirt, and so that taking a sample from that would just be the victim's blood. So, and since it was completely covered in blood, that there didn't really seem to be a need to take a sample of that sweatshirt.
And then my last question is, Judge Middleton was asking questions about whether the shoes were blood soaked or other items. How much of a potential source of DNA is there needed for you to take a swab in order for a potential analysis to be conducted?
Well, I would, just roughly speaking, the amount of sample, the DNA testing is so sensitive that it could almost be a sample that you almost couldn't even see, and still quite possibly get a DNA result out of it. So, yeah, when taking a sample from blood stains like from on the shoes and the pants, for instance, the stains were large enough to actually turn that white sterile swab reddish brown from collecting those stains. But yeah, certainly, when attempting to collect a stain, if you've identified a stained area and tried to take a swab of that area, even though you may or may not see a light reddish brown stain on that swab, it's very, very possible to actually get a DNA profile from something that you actually can't see with the naked eye.
Thank you very much. I have no further questions, Your Honor.
All right, Mr. Paul, thank you for your time. The advent of the Polycom and now Zoom certainly has saved you lab guys lots of road miles and made it easier for all concerned, at least for prelims. All right, sir, thank you for being with us. Next, you want Michelle Schmidt.
Yes, please.
Wait, hold on, I can't see anything.
Good afternoon, Ms. Schmidt.
Good afternoon.
My name is Judge Middleton. I'm here at the court in Centerville. Thank you for being with us. Prosecutor Amy Shepard has subpoenaed you to be in this matter. I'm going to ask if you would please raise your right hand.
Yes, let me just turn up the volume just a touch, please, sir. I'm sorry.
Be helpful. We had a little struggle on the last witness. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Would you state your name for the record, please, and spell both your first and last name?
My name is Michelle, Michelle Schmidt, Schmitt.
All right, Ms. Shepard.
Thank you, Your Honor. And if I may just ask very briefly of Mr. Weesey, I'd sent an email asking if we could stipulate. All right. So the parties have stipulated to Ms. Schmidt being able to testify as an expert in the field of DNA analysis and statistical calculations regarding DNA samples.
All right, you so stipulate, Mr. Weesey?
Yes, Your Honor, thank you.
I could see you nod your head, but it didn't show on the record. All right, you are qualified as an expert in the field of DNA analysis and statistical analysis. All right.
Ms. Schmidt, where do you work?
I'm currently employed at the Michigan State Police in the Grand Rapids Laboratory in the Biology and DNA Unit.
And what do you do there?
My general duties include possibly screening evidence for the biological presence, such as blood, semen, or saliva, or swabbing an object for possible skin cells, performing all steps of the DNA process, writing reports, and testifying as needed.
Now, when you indicate performing all steps, can you describe for us, is that a common procedure that you follow in performing a DNA analysis?
Yes, it is. We follow all of our protocols and procedures, and I have been trained to full competency in all steps of the DNA process.
Now, before we get into that, based on your expertise, what is DNA?
DNA is the basis of what makes us who we are. It's kind of like the genetic blueprint. You get half your DNA from your mom and half your DNA from your dad. And no two people have the same DNA profile except for identical twins. DNA can be found in every cell in the body except for mature red blood cells.
And what is DNA analysis?
DNA analysis is when we perform 4 steps of the process to then result in a DNA profile. So the first step of DNA analysis is extraction. And that's where we separate the DNA from the rest of the cellular components. The second step is quantitation, and that's where we determine how much DNA is present in the sample. The third step is amplification, And that's where we make millions of copies of the locations that we do our DNA testing for. And the fourth and final step is analysis and separation. And that's where we're able to look at the DNA in graph form and make comparisons to known samples if they had been submitted.
Now, you indicated that there were these 4 steps to result in a DNA profile. Are there different possible DNA profiles that may be developed?
Yeah, the different results for the end of a DNA process. So first, you could have a single source of DNA, meaning that the DNA arose from just one individual. You could have a mixture of DNA, meaning that the DNA arose from more than one person. And at the Michigan State Police, we will still make comparisons up to mixtures of 4 individuals. We could have the result where no DNA types are obtained. We could also have some DNA types that were obtained, but it's too partial of a sample or too partial of a profile to make comparisons. Or we could have kind of the last one is we could have too complex of a mixture, meaning that so many DNA types are present that it's just too complex and we don't make any comparisons to that result.
Now, following developing these DNA profiles, how do you go about attempting to identify whether or not a known sample is part of a DNA profile that you've developed?
So first we'll look at we'll determine if that profile, a DNA profile, is suitable for comparison purposes. Once we determine that it is, we'll then make a visual, we'll do a visual check to see, and then we perform a statistical calculation called a likelihood ratio. And a likelihood ratio is where we compare 2 very specific scenarios to see which of those specific scenarios best describes the DNA that was detected. So a likelihood ratio is set up similar to a fraction, with one scenario on the top half of the fraction and one scenario on the bottom portion of the fraction. And in the simplest terms, the top half of the fraction typically is, given the evidence, is this person a possible contributor? Or the bottom part of the fraction, given the evidence, is this person not a possible contributor? And when we determine the likelihood ratio for each of those, the larger number, either the one on top best describes the evidence, or if the larger number is on the bottom half of the fraction, that scenario best describes the evidence.
In regards to these likelihood ratios, are they then also described in a qualitative equivalent?
Yes, we have a qualitative equivalent that we also give for each of them, and that chart is listed on the final page of our report.
And talking about this report, after you go through and conduct these analyses, determining or making comparisons, if possible, with the profiles that have been developed, do you author a report summarizing your findings?
Yes, I do. I author the report, and then that report goes through a technical review by another trained scientist who's fully trained in all aspects of DNA analysis. And then there's a final review of the administrative check as well. And that person who completes that in Grand Rapids is also fully capable and trained to understand the DNA process as well.
Another thing to follow up on, you indicated that DNA is present in every cell in our body besides, I believe you said, the red blood cells. In talking about different items that you may be performing a DNA analysis from, are there some where you would anticipate it to be more likely where there would be a DNA mixture as opposed to other places?
I mean, I don't have any preconceived notions on what a DNA profile is going to look like until it's through the final step of analysis. And just to clarify, it's mature red blood cells that do not have a DNA present in them, not red blood cells. It's mature ones.
So in regards, I guess just to follow up with that question, do you find it surprising if you were to find multiple contributors on a piece of clothing for DNA?
again, you know, it depending on the nature of the clothing. I mean, if it was packaged, we may not find any DNA profile present on that clothing. So typically clothing, you could have many individuals who have nothing to do with the crime event that could be part of that. But you can also, you can easily have a DNA profile from a single source or no DNA profile. I mean, any type of DNA piece of evidence could have any of the listed conclusions or results that I previously stated.
Now, turning to the matter that we're here for in court today, did you perform a DNA analysis in a case involving a victim of Todd Schwartz and a suspect of Ethan Dingman?
Yes, I did.
All right. I'm going to briefly share my screen, and I'm going to show you what's already been admitted into evidence as People's Exhibit 14. Can you see that?
Yes, I can. It looks like the first page of my report.
All right. If I scroll down to the bottom, does that still look like your report?
Yes, it is. I can see my signature right above my title and email address.
So looking briefly at the DNA analysis that you conducted in this case, starting with, well, first of all, in regards to the notations that are used, we see that with the shoe swab, pant swab, with each of these, there's a lowercase letter that follows each of the numbers listed in the report. Can you describe for the court what those lowercase letters signify in the report?
Well, for example, we could have, each case is given an individual case number when it comes into the door of our laboratory. This case was given GR19, GR standing for the Grand Rapids Laboratory, 19 meaning it arrived in the year 2019, and then the following 7142, just the next available case number. So that's how each of our evidence profiles start. And then, for example, the shoe swab, the first swab is 1D, and 1D would be the DNA cutting that was prepared by my colleague, Paul Donald. And then once I performed DNA extraction on that sample, we then changed that number to the laboratory number, then 1E, with the E standing for the DNA extract, meaning the extracted DNA in which I'm able to visually view a graph of that DNA profile and make comparisons.
Now, in performing your analysis in this case, were you able to develop a DNA profile from GR19-7142-10DA, the swab from Ethan Dingman?
Yes, I was.
And in regard to GR19-7142-13E, were you able to obtain a DNA profile from that item as well?
You said 13E?
Yes.
Yes, I was.
And was that in order for the purposes of identifying related to Schwartz?
Yes, that 13E was came from the blood sample taken from Todd Schwartz.
Now, were those the two profiles that you then used to do your analysis of any other DNA profiles that were developed throughout the course of your analysis?
Those were the only two known sources of DNA that were used for comparison purposes against the evidence profiles that we also performed DNA analysis on.
Moving to GR19-7142-1E, the shoe swab, were you able to develop a DNA profile from that item?
Your Honor, may I please refer to my report at this time?
Certainly.
Thank you so much. Yes, I was able to develop a DNA profile from item 1E, the shoe swab, and that DNA profile was from a mixture of individuals, and that mixture was from 2 people, and at least one of them was genetically typed as a male.
And so then did you do a comparison with your known DNA profiles with the DNA profile that you developed from the shoe swab?
Yes, I did. The first comparison, we did each of these comparisons separately. The first comparison I did was comparing the DNA profile of Ethan Dingman, and the DNA profile of Ethan Dingman was excluded as a possible contributor to the mixture of DNA obtained on the shoe swab.
So what does that mean?
That means he is not a contributor to that sample. He is fully excluded.
And in regards to the profile from Todd Schwartz?
So for this case, I set up 2 scenarios to see which one of those best describes the evidence that was detected on the shoe swab. The first scenario, or the one that would be on top of the fraction, the DNA obtained from the shoe swab was from Todd Schwartz and one unknown unrelated person. Recalling that this was a mixture of 2 people, so we're just needing each part of the fraction will contain at least 2 individuals. So was that DNA from the shoe swab best explained as originating from Todd Schwartz and one unknown unrelated person? Or was that DNA that was obtained from the shoe swab best described as originating from 2 unknown unrelated people, neither of whom are Todd Schwartz? And based on the DNA results for the shoe swab, it is approximately 72 octillion times more likely it originated from Todd Schwartz and one unknown unrelated person than if it originated from 2 unknown unrelated people. And for clarity's sake, 72 octillion is 72 followed by 27 zeros. And based on that calculated likelihood ratio of 72 octillion, there is very strong support that Todd Schwartz is a contributor to the DNA profile from the shoe swab.
Moving on to the pants swab, GR19-7142-3E, were you able to develop a DNA profile from that item?
Yes, I was. The DNA profile obtained from the pants swab was again a mixture of DNA, meaning more than one person contributed, and that mixture was from 3 individuals, at least one of whom was genetically typed as a male. So again, I separately compared the 2 knowns that were submitted for this case. So the first comparison I did was looking at the DNA profile of Mr. Dingman. So the 2 scenarios that I compared in this situation, or in this scenario, were, again, reminding that this is a 3-person mixture, so both the top and the bottom part of the fraction need to have 3 individuals as part of the likelihood ratio. So was the DNA obtained from the pants swab better described as originating from Mr. Dingman and 2 unknown unrelated people? Or is that DNA that was obtained from the pants swab best described as originating from 3 unknown unrelated people, none of whom are Mr. Ethan Dingman? And based on the DNA results for the pants swab, it is approximately 2.6 billion times more likely it originated from Mr. Ethan Dingman and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And based on that calculated likelihood ratio of 2.6 billion, this analysis provides very strong support that Mr. Ethan Dingman is a contributor to the DNA profile from the pants swab.
And in regards, go ahead, no, go ahead.
I was just going to say, the next DNA profile that I then made comparisons to was that of Mr. Todd Schwartz. And again, I set up that fraction in a similar manner. Was the DNA obtained from the pants swab best described as originating from Todd Schwartz and 2 unknown unrelated people? Or is it better described as originating from 3 unknown unrelated people, none of whom are Todd Schwartz? And based on the DNA typing
Let me stop you.
Oh, sure, sir.
Lost me. We're doing interpretation of 71423E pants swabs. Okay, so it goes to the next page.
Yes,
That's
yes. Now we're
still
on the top of page 3, sir.
Page 3. Okay, got it. Okay. Go ahead, I'm sorry.
Oh, no, that's fine. Thank you. Based on the DNA results obtained from the pants swab, it is approximately 920 septillion times more likely it originated from Todd Schwartz and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And 920 septillion is 920 followed by 24 zeros. And that calculated likelihood ratio provides very strong support that Todd Schwartz is a contributor to the DNA profile obtained from the pants swab.
In regards to a sample like this, where you have 3 individuals contributing to a DNA mixture and you're comparing it with 2 different known DNA samples, why is it set up where it's with one of the known samples and 2 unrelated unknown contributors for the first hypothesis in each of them, as opposed to the 2 known contributors and a 3rd unknown contributor?
That's just the policy that we go by on how we set up our scenarios. At the end of the report, we also say if there would be another scenario that you'd like us to process or make comparisons to, we can always do that given time permitting. Unfortunately, in this case, that specific scenario in which you just described was not done. That would need to be requested. And we could do that in the future, but that was not done. So again, because we're looking at 2 very specific scenarios, I can't give you a calculated likelihood ratio, for looking at both Mr. Dingman and Mr. Schwartz as possible contributors at the same time at this time.
All right, well, can I have a question? Because this was what I was struggling with before. So we know from the past, one of the samples is a match to Todd Schwartz, one of the samples is a match to Todd Dingman, or to Ethan Dingman in that profile. And then there's a 3rd unknown contributor that isn't either one of those people. Is that correct?
There's a 3rd person that that I have not compared, and there no other knowns were submitted for this case. So I only had 2 known individuals to make comparisons to. So yes, a 3rd person, you could say that we could do more comparisons.
All right. Is there a profile of that 3rd sample that could be compared to other samples?
We compare when we're setting up likelihood ratios, we compare to the total mixture. So yes, we could compare we could compare additional individuals as well.
Is it a sufficient sample that it could be run through the CODIS system to see if there was a match with it?
No, these samples are ineligible for CODIS. They were removed from the suspect themselves, and we're not allowed to put in DNA profiles that were removed from the suspect, samples that were taken from him. So none of these samples were able to be run through CODIS.
It is that it isn't possible, it just isn't part of the protocol?
Well, the FBI sets the regulations and rules of what we can put into CODIS. So one of the first rules was a crime committed? That obviously the answer is yes, a crime was committed, so that meets that criteria. Then we also need to know that we're putting in the punitive perpetrator. And also one of the other rules is it has to be left at a crime scene. It can't be removed from a person. We couldn't remove an item of clothing from the suspect's house, knowing that it's in their possession, that then enter something into CODIS. Now, these samples were taken from the suspect, and so none of them can be entered into CODIS.
Thank you. All right, Ms. Shepherd.
Thank you. Moving on to the lens swab, GR 19-7142-7AE. Were you able to develop a DNA profile from that item?
Yes, we were. That DNA profile originated from a single individual, so just one person that genetically typed as a male. Ethan Dingman was excluded as a possible contributor to that sample. And the next likelihood ratio calculation I set up was that DNA obtained, that single source of DNA obtained from the lens swab best described as originating from Todd Schwartz, or was that DNA sample originating from the lens swab best described as originating from an unknown, unrelated contributor, not Todd Schwartz? And based on the DNA results for the lens swab, it was approximately 150 octillion times more likely it originated from Todd Schwartz than if it originated from an unknown, unrelated person. And 150 octillion is the number 150 followed by 27 zeros. And based on that calculated likelihood ratio, the analysis provides very strong support that Todd Schwartz is the contributor to the DNA profile developed from the lens swab.
Moving on to GR 19-7142-8E, the shirt swab. Were you able to develop a DNA profile from that item?
Yes, I was.
And what were you then able to compare that with your known DNA profile?
Yes, I was. That DNA profile that originated from 8E, the shirt swab, was a mixture of DNA that originated from 3 individuals, at least one of whom genetically types as a male. So again, I set up the scenario first comparing the DNA profile of Mr. Ethan Digman. So the 2 scenarios I compared to see which best describes the evidence were the first scenario, given the DNA evidence of the shirt swab, is that best described as originating from Mr. Ethan Digman and 2 unknown unrelated people, or is that DNA obtained from the shirt swab best described as originating from 3 unknown unrelated people? And based on the DNA results of the shirt swab, it was approximately 1.6 octillion times more likely it originated from Ethan Digman and 2 unknown unrelated people than if it originated from 3 unknown unrelated people. And 1.6 octillion is 1.6 with 26 zeros. And given that calculated likelihood ratio, there is very strong support that Mr. Ethan Digman is a contributor to the DNA profile obtained from the shirt swab. Next, I compared the DNA profile of Todd Schwartz. So the 2 scenarios that I set up were on the top part of the fraction, given the evidence of the shirt swab and the DNA detected, is that mixture obtained best described as originating from Todd Schwartz and 2 unknown unrelated people, or is that DNA obtained from the shirt swab best described as originating from 3 unknown unrelated people, none of whom are Mr. Todd Schwartz. And based on the DNA results obtained from the shirt swab, it was approximately 11 billion times more likely it originated from Todd Schwartz and 2 unknown unrelated people compared to if it originated from 3 unknown unrelated people. And given that calculated likelihood ratio of 11 billion, this provides very strong support that Todd Schwartz is a contributor to the DNA profile from the shirt swab.
And finally, in regard
Let me stop you right. So, and there's also 1 unknown DNA contributor in that sample as well. That's not Dingman or Schwartz.
Yes, because that was a mixture from 3 individuals. And again, this could not be put into the CODA system, but if additional knowns were submitted, we could compare the total mixture to that mixture. We could compare an additional individual to the total mixture detected in the shirt swab.
All right, now also just a minute. I'm not sure which shirt we're talking about. There's the plaid green and green shirt. There's mention of a bloody sweatshirt. Officer Donald testified about a t-shirt with writing on it. I don't believe we have in evidence a t-shirt with writing on it. So I'm not sure which shirt this is that's being analyzed.
Looking at, I don't have a copy of Mr. Donald's report in front of me, but looking at the chain of custody for the entire case file, this item originated from, the DNA extract 8E originated from the shirt. And I can see that item 9 was from the sweatshirt. So I'm not sure if there was an additional shirt that was submitted, but we had a shirt and a sweatshirt, and this is from the shirt.
All right, well, we have, okay, we'll just leave it at that. We have an uncertainty as to what shirt is what.
Yeah, I guess that would have been something for Paul to answer since he took swabs of these items. I never saw the actual shirt. It said a plaid shirt or a shirt with writing on it. So this is the evidence description I was given that's in the total case file.
Thank you.
And then moving on to item GR 19-7142-12E, the fingernail swabs. Were you able to extract a DNA profile from that item?
This DNA profile, we did perform all 4 steps of the DNA process. However, a DNA profile was not obtained from the fingernail swabs, item 12E.
Now, in regards to instances where there are potential unknown contributors to a DNA mixture, are there instances where an unknown contributor can never be identified?
Yes, there are. That happens very frequently. Many times there could be lingering DNA on objects that have nothing to do with a crime event. For example, if something happened to me and there was a crime event, but I gave my 6-year-old a hug earlier in the morning and my shirt was submitted for DNA testing, there could be DNA present from my 6-year-old that again has nothing to do with the crime incident itself and is just present kind of in the background of that object. And one, we never know the full life history of objects before a chain of custody is submitted or started once the items are submitted. So again, it's not uncommon that you could sit on a park bench and pick up a DNA profile that again has nothing to do with the crime event itself, especially on clothing of this nature, like a shirt, pants, or even just walking around with shoes, that we will never know the true DNA profile or who that DNA profile may belong to.
Thank you.
Is it true that it also could be related to the crime itself? And there's no way of knowing that.
I mean, I don't have any way of knowing that. I wasn't present at the time of the crime. So yes, it could, I mean, I guess you're right, sir. It could possibly have nothing to do with the crime event, or it could possibly have something to do with the crime event. But since these samples are ineligible to be put into CODIS, we would need known submitted for direct comparison in the laboratory here to ever know if somebody could possibly be a contributor or not a possible contributor to these mixtures.
Thank you.
Thank you, Ms. Schmidt. I don't have any further questions. Mr. Weesey may.
Just a couple, if I may, Your Honor.
Yes, certainly.
Ms. Schmidt, the work that you do in the lab is, at least in no small part, in some part, dependent upon the work done by the officers collecting the materials that are ultimately tested at the lab. Is that fair to say?
Or, I mean, I don't submit any evidence to the laboratory for testing. So yes, the people that are on the scene, the officers on the scene, or, you know, the evidence collection people are a vital part of this process.
So hypothetically speaking, if I'm an officer and I'm going to collect shirts, pants, shoes in sequence, and just if I have an area of a table and I'm going to lay them out to photograph them, and I put a piece of paper down and across the table, and then I put an item on it, photograph it, take a second item. Would you want me to change the paper that I have between the items and the table before I process each item? Would that be optimal for your work in the lab?
Yes, that would be optimal, just like we always suggest to the officers collecting the evidence to package items separately as well. Now, sometimes when, for example, pants, like if a belt was attached to the item, I mean, that's how they were taking them off. So that's not necessarily as problematic. And certainly like shoes currently with shoelaces, again, you wouldn't have to like remove the shoelaces from the shoe, but yes, we wouldn't want to commingle or place down on the same piece of paper multiple items of evidence.
Same line of thought. Would it be optimal for me to change rubber gloves between touching one item and another and placing each item in a bag for the next step?
That would be optimal, or you could bleach your gloves down in between touching them as well.
And this would again be to avoid commingling?
Or yes, it would be. So you would be, each item would be being touched. Like, so if I were performing analysis on the items, I would open a single bag, and the single bag would preferably have just one shirt in it. I would have a clean piece of bench paper out. I would have new or freshly bleached gloves, and then all of my utensils to examine that item would be cleaned, freshly bleached down items. Now, certainly, again, like I had previously said, it's not always possible, but in this case, if it could be collected that way, that would be optimal. Now, many times we do get something where these items were found, say, in a dumpster. Now, certainly when they're in the dumpster, they're all together, but then best practice would indicate, let's separate these into different bags when we submit them to the crime lab.
And this commingling would allow for a transfer of DNA.
Yes, anytime two objects come in contact with each other, there could be a possible transfer of DNA. That is possible.
And getting to your example that you gave, I was sitting on a park bench, so safe to assume then that these obvious touch transfers or transfers of DNA very easily can occur?
Sure, that could be, yes, it could. I mean, obviously, when you go to sit down on a park bench, you're not putting like a clean piece of bench paper to sit on. You're not bleaching down the bench itself. So yes, you could have DNA transfer that the person prior sitting on the bench, DNA could transfer that way as well.
Thank you very much, ma'am. I appreciate your time today. Nothing further, Your Honor.
All right, Ms. Shepherd, anything further for Ms. Schmidt?
No, thank you, Your Honor.
All right, thank you. You mentioned additional report. Ms. Schmidt, you're free to go. I'll remove you from the feed and you can go back about your business. Thank you very much.
Have a nice day.
Thank you.
Yes, Your Honor. Pursuant to MCL 766.11B1D, we would move to admit into evidence GR 19-7142, record number 1. Again, I was waiting to send a copy to the court before, waiting for confirmation one way or another from Mr. Weesey to see if we needed to discuss this with you on the record or if he would stipulate to it. I never heard back from him. However, I am prepared to email a copy over that in addition to sharing it on the screen. I am prepared to.
What is it? What is it?
It's a laboratory report involving the on-scene investigation on the day that Mr. Schwartz was found inside of the garage.
Mr. Dingman, there is a rule which she cited in the Code of Criminal Procedure which allows laboratory reports to come in under limited circumstances at preliminary examinations without the big laying of a foundation. And so it's for preliminary examination, probable cause purposes only. That's how we got the first two reports, and then we ended up taking testimony about them. This is a report I have not seen, which they're asking to admit under the special exception for preliminary examinations. Mr. Weesey, what's your position regarding this exhibit?
I believe that report pertains I understand the rule that's been cited. I fail to see any relevancy with respect to the preliminary examination.
Anything further you wish to comment regarding that?
No, Your Honor.
So you won't stipulate to it?
No, Your Honor.
All right, well, it doesn't necessarily require stipulation, but he argues that it's not relevant. What's your response to that?
Our argument is that it is relevant. It continues to describe the condition of Mr. Schwartz as the forensic technicians found him when they were conducting the investigation on scene. It is their laboratory summarization of what that is, in addition to the additional information that they took into consideration while performing that evaluation. It's a laboratory report by the Forensic Science Division of the Michigan State Police, specifically MCL 766.11b, does indicate that, except for the police investigative report, which this is not, a report prepared by a law enforcement officer or other public agency. Reports permitted under the subdivision include, but are not limited to, a report of the findings of a technician of the Division of the Department of State Police concerned with forensic science, a laboratory report, as well as other reports that are listed. So it clearly falls under the rule of 766.11b. It's relevant to the findings that they made there on scene that day. And so the court should be able to consider this report as it's making the determination of probable cause in this case.
Is there also a concern about hearsay evidence that this report is purporting to show what? One of the concerns I had, and one of the reasons I gave you an additional week, is I don't know anything about the scene. I have some little snippets of testimony. I don't know if there was a car in there. I don't know if it had a dirt floor or a cement floor. I don't know if there was windows open. I don't know if there was a light on in there. I heard testimony about bloody footprints on the floor. I've seen no pictures of bloody footprints. That's what I mentioned last week when I said there was no there. There's just a body in a garage, and the rest of it is unknown, at least unknown to me. He's objecting to this admission at this point. The people that are making these conclusions aren't here, and I haven't seen the report, so I can't look at it and say, yeah, this is hearsay, or yes, it isn't. You quoted the rule accurately, except for the police investigative reports, a report prepared by a law enforcement officer or other public agency. The reports include, but are not limited to, the report findings of a technician of the Division of the Department of State Police concerned with forensic science, which appears to be what this is. A laboratory report, a medical report, a report of an arson investigator, and an autopsy report. So it does appear to be allowed by the specific court rule. It went into effect, I think, after I was prosecutor and after I'd become judge.
Your Honor, just to follow up on the hearsay concern, the rule explicitly states in Section 1, the rules of evidence apply at a preliminary examination, except that the following are not excluded by the rule against hearsay and shall be admissible at the preliminary examination without requiring the testimony of the author of the report or authentication.
That was the purpose of it. So I will admit the report, which I haven't identified yet. It is to be People's Exhibit number 15.
Yeah.
All right, you may publish it.
I've also, for the convenience of the court, emailed a copy of it to Your Honor as well as Mr. Weesey, so that he is CC'd on that communication with Your Honor.
Well, this changes everything. At the 11th hour and the 59th minute, you put in the evidence that I've been waiting to hear about. as I said, I know nothing about what happened at the crime scene. No description of the garage, no nothing. And you rested, and I gave you an additional week, and I guess the additional week led to your admission of this. So I'm gonna have to read this carefully. And it may affect my ultimate thinking about what to do here. So I'll receive it, I'll print it off my email. Let's take a recess until, and Mr. Weesey, you've seen this before, but you didn't know it was gonna be admitted until earlier today. Oh, this is pages long. But you've had a copy of this, is that correct?
Yes, Your Honor.
Okay. All right. Let's take a recess until 3 o'clock. I will review exhibit number 15. Mr. Dingman, you can have a break for a few minutes while I review this evidence. And this isn't a shoot from the hip kind of thing. I'm gonna have to read this carefully. All right, let's take a recess until 3 o'clock. Thank you. I'm gonna leave the light feed on. Well, we have everyone but the defendant, so as soon as we get him, we'll be ready to resume. I've got another pen, but I still don't have the defendant.
Deputy Bradford.
Hi, Deputy Bradford. Is everything okay with Mr. Dingman?
As far as I know.
Okay, we're ready for him back in the room.
All right, we'll do.
Thanks.
Bye.
There we go. Welcome back, Mr. Dingman. All right, we are back on the record in the matter of People versus Ethan Dingman. All the parties that were present previously are present once again. Any further evidence, Madam Prosecutor?
Your Honor, if people would briefly call Chief Brinker.
All right, Chief Brinker, let me swear you under oath once again. Would you unmute your microphone, please?
Yes, sir.
Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
And once again, would you state your name?
Mark Brinkert, Brinkert.
All right. Yes, you may inquire.
Chief Brinker, turning back to November 21, 2019, when you responded to the garage at 224 South Blackstone Avenue, can you describe for us the layout of that garage?
Sure. The garage is located off an alley, which is behind or to the west of the residence, 224 South Blackstone. It's a two-story garage slash barn. I opened the walk-in door, which is on the east side of the barn. And that's how I was able to get in. The inside, typical barn, tools, had a cement floor. I don't recall if any windows were open or any other door was open, except for the walk-in door.
And in regards to that walk-in door on the east side, was that the only way that you found to be able to gain access to the garage that day?
Yes, it is.
Where was Mr. Schwartz positioned inside of the garage?
So as you walk in the door, he was approximately 3 feet inside the building. His feet were to the south of the building. His head was to the north.
I believe you originally testified on direct examination regarding making certain observations while they're inside the garage, including well, rather than me making an assumption based on potentially faulty memory, what, if anything, did you observe when you came into that garage?
The decedent was on the floor, his spine or on his back. There was a towel underneath his head and what appeared to be partial footprints in blood, which would have been on the west side of the body or the right side of the body near the head.
Did you also observe a pool of blood in the garage?
Yes, near the head.
About how far out, if you remember, did it extend?
Maybe 4 or 5 inches at the most.
And about how far outside, if at all, were these footprints on the west side?
Maybe 7 inches, 7 to 10 inches.
And if I just may have one moment. Thank you, Chief Brinker. I don't have any further questions.
Mr. Weesey?
Did you actually take measurements of these observations, or are you guessing today?
I did not take measurements.
Okay. So what are you basing your testimony on?
My visual.
Okay. And as I understand your testimony, you don't recall if the windows were open or not?
No, sir, I do not.
Okay. Thank you very much, Your Honor.
Well, this is 7 o'clock on the 21st of November. It's dark. Are there any lights in this garage?
If I recall right, yes, there was a light on, but I'm not 110% sure.
Was it already on or did you turn it on?
No, I didn't touch anything except to feel for a pulse.
All right. Was it dark outside?
When I first arrived, yes.
All right, thank you. Anything further?
No, thank you, Your Honor.
All right, any further evidence?
Your Honor, there are a series of photographs that are referenced in the People's Exhibit 15. I would argue that they're incorporated into that report by that reference. However, I would concede that that's not something that's clearly articulated one way or another by MCL 766.11b. My additional concern is that those photographs do contain photos of the deceased, and given the very public nature of these proceedings these days because of the pandemic, with items being broadcasted to YouTube, that is why we've hesitated to put them on for sharing, given the public nature and the longevity of things once they go onto the internet. I did email Mr. Weesey in regards to very limited photos for a stipulation. I never heard back from him in regards to those. It was not in regards to all the footprints, but particularly the footprints found on Mr. Schwartz's person. For that limited purpose, I would move to have those 3 photographs considered by the court as being incorporated in People's Exhibit 15, but do anticipate Mr. Weesey may have some objections to that.
Mr. Weesey?
I do object as to lack of foundation, Your Honor.
Yeah, we've been going after a moving target. I gave an additional week and then we heard something and now I hear something else. And then I was reluctant to tell her how to conduct a preliminary examination, what I was looking for. It's their choice to present the evidence in the manner they wish to. Certainly no preliminary examination do they present all the evidence. It's just a matter of probable cause. But I will just go with the report. At this point, I had more information, double hearsay, but it's admissible in the report. A little update from Chief Brinker. In looking over the notes, I had very little information about the crime scene, a brief. Anyway, your objection is sustained. We'll go with the exhibit as it is and proceed from there. Anything further?
No, thank you, Your Honor.
All right, now it's time for argument.
Thank you, Your Honor. Based on the information that was supplemented today, as well as the testimony that the court has already considered last week during the proceedings of this preliminary examination, the people do move for binder. As the parties have already, I think, if not stipulated to conceded, a crime has been committed here. That's not really where the inquiry of probable cause rests. We have both the forensic pathology report, People's Exhibit 1, as well as the testimony of Dr. Joyce DeYoung regarding the cause and manner of death of Mr. Todd Schwartz, that it was a strangulation, blunt force injuries to the head and to the chest that ultimately led to his death, and that was ruled in the manner of a homicide. So what we're left with is determining whether or not there's probable cause that Mr. Dingman is the individual who inflicted those injuries that caused the death in a way that's not excused under the law. The evidence in this case does provide probable cause for that. And I think it is important to take into consideration as we analyze both the evidence from last week as well as what we considered today, what the physical evidence that Dr. DeYoung described to us takes into consideration. So first of all, we have this blunt force injury that occurred. He testified that it was likely from either a push or from a fall and him hitting his head hard against the ground. That's why we have the laceration on the back of the head, as well as the contra-coup injury to the front of his brain. Taking that into consideration with the other injuries that she identified, he said that there was this bruising to the chest, the contusions noted in the chest. Most were colored purple or blue. However, there was a yellow-red abrasion to his sternum as indicated in the pathology report. And on her testimony, she indicated that likely this injury was inflicted during the perimortem period. The perimortem period being as Mr. Schwartz is passing away. Based also on the mechanism of the injury to the back of the head, we would expect that he's already on the ground then when this injury is being inflicted. And it's being inflicted in the manner of a blunt force injury. Now, the reason why I bring this back to the court's attention is to take into consideration the totality of the evidence that we have before us. We have footprints in blood, also based on People's Exhibit 15 on the decedent's body, there is what is an apparent footprint on his jeans. The foot is certainly capable of inflicting blunt force trauma in the form of a kick, of a stomp, of a swipe. When we're talking about these blunt force traumas, and it would be a reasonable inference to believe that the injuries that are occurring or these other blue contusions, purple contusions occurred at about the same time or in the time leading up to this yellow-red contusion. So as he is on the ground, it is a reasonable inference also then that the individual who inflicted these would then walk through the blood that is being, that is pouring out of Mr. Schwartz's head at this point as he's already on the ground. We understand that this injury would have happened while he was still alive. And again, noting, while she said that it was impossible to completely give a time to when everything occurred, given that yellow abrasion to the chest, it makes sense that this would have happened after the injury to the head. So his head is already bleeding, already leaving that pool of blood for the individual who's there who intentionally inflicted these wounds to then walk through that blood and leave these footprints behind. We also have then the DNA analysis that was conducted on the shoes of Mr. Dingman. They were swabbed, they were identified to see if there was any presence of blood. We had the testimony from both Mr. Donald as well as from Ms. Schmidt in regard to what the result of those analysis was. We had the testimony that very little DNA, in fact, needs to be left behind because their testing instruments are so sensitive that they would be able to pick up even a very minute, almost unseeable amount of DNA present. We have the pictures of the shoes in regard to that. We also saw the pants and that Mr. Donald, in fact, testified that the items were at the cuff and near the knee of his pants. So we're not talking about someone who had just walked in to an area to see this blood, but it's on his knee. It's not just on his shoes. It's near the cuff area of his pants as well. And that upon taking those swabs and being submitted to testing for DNA, that they did come back indicating the presence of Mr. Schwartz's DNA on Mr. Dingman's clothing. Now, yes, in regards to particularly the shoe swab, that there are potentially two contributors to that DNA profile. Ethan Dingman, these are Ethan Dingman's shoes. He has been excluded as a person who's a contributor to that. However, there's very strong support that Todd Schwartz is a contributor to that DNA profile. Todd Schwartz being the one whose blood is all over the floor of the garage where he is found deceased. We had testimony from both Mr. Donald as well as Ms. Schmidt, how it's possible that we may never find out who another contributor is, that DNA can be picked up along any ways. Thinking specifically of shoes, especially about the testimony that we heard last week from Chief Brinker, that Mr. Dingman was known to be between different addresses, kind of roaming, not in a single location. His shoes are going many places. There's a chance his shoes are going to pick up DNA in many places. However, Mr. Donald indicated he does his best to find or to limit the amount that he's picking up to try to narrow down that DNA analysis. And what it comes back is he has one unknown contributor, but Todd Schwartz. And again, this is on Ethan Dingman's shoes on his person. The same goes for his pants. Again, the high likelihood that there's different DNA profiles that get left on individual clothing. However, in addition to finding Mr. Dingman's DNA on his pants, Mr. Schwartz's DNA is found. And again, I think it's very important to note when we go back to People's Exhibit 13 and the testimony of Mr. Donald, it's not just random DNA that we're talking about. The source is identified. It was the possible presence of blood that then the item was swabbed and sent in order for the DNA extraction to be located. We talked about this last week, but then we also have these glasses that were recovered with a single contributor. Those glasses having the DNA of Todd Schwartz on them. And that also, he was known to wear the same type of glasses, that these glasses were taken. There's probable cause to believe that these glasses were taken from Mr. Schwartz during the course of this assault. They maintained his blood on them, and they were found on Mr. Dingman's person. I know there was some confusion regarding the shirt. The GR 19-7128 is not the shirt that there's a photograph of in evidence. It's a separate shirt. However, GR 19-7142-8 is a shirt as opposed to the sweatshirt that was described in GR 19-71429. That sweatshirt belonging to the victim, as both Donald testified, but also is supported by People's Exhibit 1 from Dr. DeYoung, who indicated that on Mr. Schwartz's person was a gray sweatshirt. So that can go back and can be referred to in terms of the external examination of Mr. Schwartz. I believe that the third item listed there is the gray sweatshirt that he was wearing. So taking all of these things into consideration, we have an individual who was found deceased on the scene. He's been assaulted. The assault was in the nature of these blunt force trauma as well as a strangulation injury. The blunt force trauma, again, we talked about it with being with a fall. Dr. DeYoung said she could not definitively say what object it was caused that blunt force injury to the chest area. However, we know that that's occurring towards the end of Mr. Schwartz's life because of that last groove that was left, indicating the blood's already pooling around his head, that the individual who's inflicting these, whether it is with their feet from kicking or stomping or using some sort of object, would then be able to walk through the puddle of blood, pick up Mr. Schwartz's DNA, and have that present on their clothing. The last thing that the people would refer to in regards to the People's Exhibit 15 is the information available there regarding Mr. Dingman's activity after calling 911, that he had been in the bathroom at the Shell gas station for a long amount of time. They did go and try to process that bathroom for the possibility of evidence, but that there were some things that were indicative of possibilities, but when subjected to further presumptive testing, were not coming back as presumptive. The people would say that the reasonable inference from that was that while Mr. Dingman was in there, he was able to have time to wash his shoes, to wash other parts of his body in order to try to get rid of this evidence. And as a result, it may not have been as apparent as if he had been apprehended as soon as this incident occurred. However, as Mr. Donald said, a small amount is all that's needed for them to be able to create these DNA profiles, and that's what they were able to locate through the course of their analysis. So based on all of this, the people do believe there is probable cause to believe that Mr. Dingman is the individual who inflicted. Now, when we're talking about probable cause again, when we're in the course of a preliminary examination, what the people need to present is evidence supporting that the defendant perpetrating this crime. That evidence can be circumstantial. We can see the circumstantial evidence in this case, but the case law is clear in People v. Ferry 325 Mich. App 645 that evidence may be circumstantial. Also, the district court is able to rely on inferences in order to establish probable cause for the purposes of bindover, and that's located in the same case as well. So for these reasons, we do ask that the court would bind this matter over for court, even if in the court's own mind there was a matter. I should rephrase it this way. I believe the questions that have been raised at this point with Mr. Weesey's argument last week that this is just a person who found a body, called 911. That's why his DNA is on there. That's a question of fact. The theory presented by Mr. Weesey versus the theory presented by people present two different factual scenarios and factual questions. And those types of factual determinations need to be determined by the trier of fact, and that's a jury at the trial. And so we would ask that you bind the matter over to circuit court for these reasons. Thank you.
Mr. Weesey?
Thank you very much, Your Honor. Well, Ms. Shepard certainly does state forth the standard for probable cause. I think that the arguments that are been offered and will be offered again here today are probative to that analysis in and of itself, certainly not to try to create any type of alternative theory or anything of that, but we have to explain or look at the facts as they're presented. And if we listen to the government's argument here today, it's, quote, again and again and again, and it's DeYoung and DeYoung and DeYoung. Dr. DeYoung didn't testify here today. Dr. DeYoung didn't have any supplemental information here today. None whatsoever. This argument has already been made. Your Honor has already indicated what it thought of that argument. So let's look at what we had here today. Paul Donald, biology. Okay. Came in and he just walked us through what he essentially read his report. There's very little probative or new information with respect to his testimony here today. And it has little, if nothing at all, to do with Dr. DeYoung. He came in, read his report, took a look at the photographs again, had the report last week, had the photographs last week, can't see anything on the photographs, can't really see anything on the shoes. Well, what about that spot on the bottom of the shoe? No, that's just dirt. Can't really see the blood, but it's there, it's spatter, it's small, it's microscopic. Oh, okay. We knew all that already. It was in his report a week ago. The only thing he says here today, he says, well, we can't see it. We have to use these special lights and whatnot to ascertain. And then this test, he described the test and the process and the procedures. The test and the process and procedures were interesting to hear and certainly, it was informative, but it offered nothing with respect to the probable cause analysis. Some of the stuff was on a knee. Okay, well, somebody found a body and somebody called 911 and DNA on a knee. And DNA on a knee on a person who finds a body and calls 911 and then stays on scene is probative of murder. Makes it more probable than not of murder. Donald described cuffs, marks on a cuff, microscopic marks on pant cuffs, whatever. Again, somebody who's on the scene found the body. Then we heard from Ms. Schmidt. Again, very intelligent, capable, informative scientist. Walked us through the processes, walked us through the procedures, offered us some ideas as to, wow, maybe some of the ways in which the DNA that was collected here, in this case, wasn't really done up to optimal standards. But what substantively did she offer in terms of probable cause that Mr. Dingman did what Dr. DeYoung describes? Nothing. Nothing. Came in, literally read her report. Your Honor, I did the same thing you did. As she was going through it, there was one point in her testimony where, like, wait a minute, there might be something new here. Oh, no, we got to turn the page. And she just kept reading. Oh, okay, but we had this a week ago. And it doesn't add anything that makes, that's any indicative of a probable cause. Finally, we have the report from the scene, and Your Honor says, well, okay, maybe this is the 4th and 10 Hail Mary, or I forgot the analogy that Your Honor used, but if you go through this, there's nothing in this report that's probative of that Ethan Dingman did anything here. So Ethan Dingman, and the testimony is replete with the fact that, wow, we observed him and he was off in space. face, and he was saying all of these bizarre things, and his mood and tone and demeanor and mannerisms were all over the place. They're up, they're down, he's cooperative, he's belligerent. All of the police testified last week as to all of that during their dealings with Mr. Dingman. But we're here to think that this gentleman went to the Shell gas station and left a pristine scene, and that's the probable cause of murder? That Ethan Dingman committed the act described by Dr. DeYoung? The more we get into this and the more evidence we hear and the more people that come in and testify, the more exculpatory information comes out. Finally, we had Chief Brinker. Famous saying, well, I'm not 110%. Well, I came in through this door. Well, I did note other doors and windows. Were they open? I don't know. Well, I think this was 7 inches. This was, did you measure it? No, just guesstimating. I'm not 110%. Same officer who was on the crime scene, I believe he testified last week for 3 to 5 minutes. I think it was less than 5, much closer to 3. Has a 2 minutes of questioning or very brief questioning with Mr. Dingman. Comes back to, there's my guy, not 110%, but got my suspect. Your Honor, there is absolutely nothing that would link Mr. Dingman to this offense, to having committed this offense. He found the body, went to the Shell station, called 911, stayed on scene. What happens after that? It says a bunch of bizarre stuff, which Your Honor has really already indicated is probably more exculpatory than incriminating, and probably not going to be admissible anywhere down the road, if even here today, because he was in custody once he was taken from the front seat to the back seat of the squad car. Which leads to something even more problematic for the government here today. When we last left the court, we were hung up on DNA, where Your Honor seemingly had some, and I would describe it as Your Honor thinking out loud, which we all do, okay, on DNA, and whether this unknown donor might be relevant or whatnot. And Your Honor made a statement that Your Honor actually stopped it yourself and said, yeah, if it even matters. And I think that reaction is exactly right, and it doesn't matter. What matters here is this: if we get to that point in the case, the scene, the investigation, wherever, and Mr. Dingman's been questioned 4 times, and the 2 detectives stand up. They take a 3, 4, 5 minute break, whatever it was. They go into another room in the administrative room. They talk to the prosecutor. Prosecutor says, okay, we got enough. Then we start seizing clothing and items and whatnot. If Your Honor doesn't think and didn't think there was probable cause coming into court here today, and today was all spent on DNA, we don't even get to the DNA testing. If he's arrested, seized, searched, and his clothing is stripped to submit to the lab for that analysis, if they don't have probable cause to arrest. You'd have to have probable cause for exigent circumstances. We don't even get to the lab report. Your Honor, this case cannot and should not survive bind over. It cannot and should not proceed to trial based upon the record that's been submitted to the court. I respectfully ask that you dismiss the case at this time.
Last word, Ms. Shepard.
Thank you, Your Honor. I do find it interesting in Mr. Weesey's argument that while he considers much of the evidence that the people have presented, continues to ignore an important piece of evidence that the people have admitted, and that's that Mr. Dingman had Mr. Schwartz's glasses with Mr. Schwartz's DNA on his person. That's a fact that simply cannot be denied. It goes beyond a question of whether or not this person is calling 911. It shows how close he was at this time to the individual. It puts him on scene. And again, the DNA on his shoes puts him in the place of where this incident occurred. Second of all, and again, while I don't think this is necessarily relevant for the purposes of bind over, the items that were seized from Mr. Dingman's person were seized pursuant to a search warrant. So they had the probable cause. They had a search warrant issued by a magistrate that allowed them to seize these items. We would get this situation where then we have the DNA analysis that comes back with the DNA on Mr. Dingman's clothes. The DNA that shows is Mr. Schwartz's DNA that ties Mr. Dingman not just to calling 911 on the scene, but the fact that he had contact with the blood on that scene of Mr. Schwartz, that contact came in the course of him conducting this assault against Mr. Schwartz that ultimately led in his death. There are questions of fact here, Your Honor, but again, a question of fact is for the fact finder to decide at a jury trial. This matter should be bound over to circuit court, and we ask that you would do so. Thank you.
Thank you. I wondered if you were going to mention the glasses. That's the single most compelling piece of evidence that there is. I'll get to that, but we don't even know whether they're Mr. Schwartz's glasses. And the standard, everybody understands, is a probable cause standard, not a proof beyond a reasonable doubt standard. So there are lots of unanswered questions that don't necessarily need to be answered if the people can come up with sufficient probable cause to bind the matter over. It doesn't really matter. Do the bloody footprints in the garage match the shoes? Is there other evidence that we don't know about? Eyewitness testimony or testimony from the 911 tape or testimony from people in the store or other things that doesn't matter. What matters is there sufficient probable cause here to bind the matter over, and it really rests on a couple of small samples of blood. Let's start with a time frame, and I may have done this a little bit last week, from the defendant's tenure in jail, which is now 595 days in jail. He got arrested on April 21st, and I had the same thought that Mr. Weesey had. They did some interviews, and arguably everything said to the officers at the Sheriff's Department is inadmissible. Nothing was really strongly argued about that. Officer Nails said he gave 4 different statements, but he was in custody. He was mentally ill. The prosecutor described him as a paranoid schizophrenic. He was actually very strange. He's 19 years old. He'd been in the back of 2 separate police cars. They took him all the way to Centerville and took him inside to do a recorded interview, which was not recorded. And no one ever thought to advise him of the Miranda rights. But we aren't rising and falling on that because none of those statements are being considered here. I had the same thought Mr. Weesey did. If the prosecutor had submitted for an arrest, I didn't know what happened. I knew Mr. Dingman was arrested. I knew Mr. Schwartz had died. I didn't know how he died. I didn't know if he was shot or stabbed or strangled or hit over the head. I just knew that he died. I didn't know anything about it. There was no probable cause affidavit. There was no bond sheet. There was nothing. He was simply charged on a short form open murder complaint saying he did kill Todd Schwartz, did murder. I had the thought that if the prosecutor had submitted for an arrest warrant, at the time they made the arrest, there wouldn't have been enough probable cause to arrest him. We certainly didn't have any of the DNA evidence you have here. So you take that out, you got nothing. You got a dead body and you got a young man that called it in. I don't believe there was probable cause at that time to make an arrest, but he got arrested. Sometime between 7:11 and 7:41, probably closer to 7:11, Chief Brinkert says on the hot mic, "I think I got my guy, I'm just not 110% sure." So within 20 minutes of the time he got there, Mr. Dingman was the suspect. So on the word of the prosecuting attorney with a non-recorded non-Mirandized statement, the defendant is arrested. The magistrate sees him on November 22nd and bond is denied. Mr. Weesey appears on the very same day. I don't know if he's kill, Bill, kill. They were trying to call on the phone, but Mr. Weesey appeared very quickly thereafter. Preliminary examination was set for December 3rd, a pre-exam conference. And at that point, the officers were still finishing police reports. Mr. Weesey was filing discovery demands. They were just trying to figure out what was going on. So it was set for a prelim on December 10th of 2019. And the prosecutor asked for a competency evaluation, said the defendant was a paranoid schizophrenic. I had engaged a little bit with Mr. Dingman in the early stages of this via this kind of a Zoom or Polycom link, and he certainly did seem very, very disoriented. So on December 10th, I ordered that he undergo a competency evaluation and set the pre-exam conference for March 3rd. On that day, I signed the order for competency evaluation. Then we got an input from the Forensics Center in January 31st. We had a first competency hearing on February the 5th, and the defendant was found to be incompetent. He was not able to assist in the understanding of the facts and aid in his defense. It was the opinion of the forensic examiner that the defendant was incompetent. So everything stops. That report was dated January 28th of 2020. He was so mentally ill they couldn't do any testing. In my opinion, Mr. Dingaman was incompetent to stand trial. He appeared actively psychotic, in which he displayed loosening of associations and an inability to discuss the events that led to his arrest in an intelligible manner. That was 2 months after the arrest. And my fear is, at that point, all the investigations stopped. The defendant got arrested. He was a suspect within 20 minutes. Within 2 weeks or 2.5 weeks, he was evaluated for competency, and it takes a long time. So we issue an order in February of 2020 that the defendant is incompetent. It takes all the way to August of 2020 before defendants admitted to the Forensic Center for treatment. He was awaiting placement from his evaluation in January to August. So we got updates. At that point, after August 18th, I believe it was after the, no, it was before the primary, it was after the primary election, but before the general election. The special prosecutor was appointed for Kalamazoo County, and Ms. Shepard is gracing us with her appearance on that appointment. And these are very difficult cases to inherit from someone else. So in October of 2020, the Kalamazoo County prosecutor is now responsible for the case. Mr. Marvin had been elected as prosecutor-elect, and he had had some very brief contact with the defendant. So he disqualified himself, and Kalamazoo was appointed. So I don't know what happened, if anything, between defendant's arrest in November and the time the special prosecutor was appointed in October. We got a treatment update in November 9th. He was still incompetent. We got a second 90-day report in February of 2021. He was still found to be incompetent. We got another report on April 9th of 2021, 21, finding that the defendant had been returned to competency to stand trial. Mr. Weesey had some objections to that. Judge Pattison held a comprehensive competency hearing, taking testimony, found the defendant to be competent, and with some struggles, the matter was set for prelim for June 1st. And as of today, the defendant has been in custody for 595 days with his bond denied. So finally, on June 1st, do we start to hear some testimony about what happened. That was the first I knew as to how the decedent died. Now, that's not necessarily unusual, but I came into this preliminary examination with no preconceived ideas about anything. I knew very little about it, other than the defendant was struggling with mental health issues. So let's go to the timeline of the day that this happened. November 21st of 2019, a 911 call comes into our central dispatch. I believe at 9:52. November 21st is a Thursday. It's dark out. It's presumably cold out. And they get a call of a medical. Trooper Burgoyes arrives at 6:55, and the defendant comes out of the Shell station. And in her testimony, he has a 1,000-yard stare, and he is not processing what was being said. He did say something like he'd been over there or something. But she told him to stand by the patrol car. Officer Brinkert is there, and he went in the garage through the side door and saw the decedent and some blood. I'm presuming there must have been some light on in there because it's still dark. I didn't know anything about what the garage looked like, or we'll talk about that in a bit. I got more information today. Officer Brinkert interviewed the defendant briefly outside the car, and somewhere during that period of time, between 7:11, he gets out of the car, and that's when he makes the statement, "I think I got my guy, I'm just not 110% sure." So then he gets out of the car at 7:43:49, according to cross-examination, and says, "I don't know if he's out of his mind or just a dumbass." So at that point, the defendant had been in the front seat of Mr. Brinkert's car. Then he was placed in the back seat, locked in the back seat of the car, while he went in and took pictures. There was some other interviewing, and that's when it says, "I don't know if he's out of his mind or just a dumbass." Then he's taken out of that car and put in the back of Deputy Bingham's car. Then he was transported to the jail, and I wasn't clear whether Officer Brinkert transported him or Deputy Bingham transported him. Instead of going to the Colon Police Department, which would have been just down the street for further interview, he was taken to the Sheriff's Department, allegedly, so they could videotape the interview, which they failed to do. Then at 9:30-ish, according to Deputy Males, they start their non-Mirandized interview with a schizophrenic 19-year-old man, and that interview ends at 1:30-ish. And at 13:29, the defendant was placed under arrest after a brief consultation with the county prosecutor, and then he was given his Miranda warnings. On December 4th, the evidence was sent to the lab. On March 9th, those lab results were completed, and later the results were sent back in the reports. Officer Mail said the defendant made lots of random statements that made no sense and he would go off on tangents. What I knew about the scene before today, Officer Burgoyce went in and looked at the scene briefly, saw a white male on the floor with his arms and legs at his side, a piece of cotton or pillow under his head, which was interesting to me. It's doubtful the defendant put that under his own head, or the decedent. Someone apparently put something under his head. She saw blood and bloody footprints and splatter marks, and according to Deputy Herman, there were pipes on the victim. There was a large tear in his blue jeans. His pant pockets were inside the pants. They searched the house, found some evidence of drug activity and some bananas, and I don't know, nothing to indicate that it was the scene of the crime. Then, today, with the admission of Exhibit 15, we learn a little bit more about the crime scene. The crime scene response team arrived at the scene at approximately 2:21 p.m. on November 21st. A pre-scene briefing was conducted by investigating officers with the following information given. Hearsay and hearsay, but it is in the report and it's admitted. Investigators were initially called to the residence on a medical call. First responders discovered the decedent in the unattached garage of 224 South Blackstone Avenue. He was the homeowner, according to investigators. He was found lying on his back in a large pool of suspected blood around his head. There was some sort of cloth under his head. Footwear impressions in suspected blood were observed around the victim's head. There was also suspected blood splatter observed near the victim's body. Upon this discovery, responders backed out of the scene without approaching the body. Here's some more hearsay contained in the hearsay. Investigators advised the suspect had called 911. He had called from the Shell gas station located next door at 226 South Blackstone Avenue. He reportedly entered the gas station and went into the restroom for an extended length of time. The restroom was secured pending crime scene response team processing. So someone from the gas station told someone who told them that he'd been in the restroom for an extended period of time. And the prosecutor argues that he had time to go in there and clean himself up. We don't know how long he was in there. We don't know if it was before he called 911 or after. And there's no testimony that he was covered in blood or anything when he went into the Shell station. But the suspect was later apprehended. He reportedly had the victim's glasses in his possession and suspected blood on his clothing. The response team advised the suspect had been staying at the victim's residence on and off for the past several months. More hearsay on hearsay. The weather at the time was approximately 48 degrees with light rain. My questions about the garage. The garage of the residence was 2 stories and constructed of wood. The floor of the garage was cement. The garage had an entryway facing east and a sliding bay door located on its west side, leading to an alley that ran north and south. The decedent was located in the southeast portion of the garage. He was lying on his back with his legs oriented to the south and his head to the north. His arms were extended at his sides. He was wearing a dark gray sweatshirt with a lighter gray shirt underneath. He was also wearing blue jeans, white socks, and black shoes. Possible footwear impression was observed on the right leg of the victim's jeans near his knee. There was cloth under the back of the victim's head and a significant amount of apparent blood around his head. Footwear impressions, footwear 1 and footwear 2, were observed to the east and west of the victim's head. The impressions appeared to have been made in blood. There was suspected blood spatter observed on the floor, as well as several items in the garage near the body, including a shovel and a green plastic tote located to the north of the victim and a garbage can to the west of the body. There was an apparent observed wound on the defendant's chest, with some bruising observed on the chest as well. Somehow, the wound was observed on the back of the decedent's head as well. We know that the decedent had amphetamine, methamphetamine, and fentanyl in his bloodstream, which did not appear to contribute to the cause of death. So we know a little more about the scene. It was relevant to me whether the floor was dirt or cement. There's some argument that the defendant hit his head, but we don't know that. The testimony was it was a blunt force injury. He was also strangled, and someone placed a cloth or pillow under his head. I couldn't tell whether he died there or was moved there from somewhere else. The autopsy report says that livor mortis is dank and distributed dorsally, is dark, meaning he was on his back. So it didn't appear he died on his stomach and they rolled him over. He was on his back. He had cuts in his pants and a blood stain beneath the knee. He was alive when the head and neck injuries were occurred. Prosecutor argues somehow that there's some evidence that he was stomped on by a shoe, causing injuries to the chest. I don't know. I think that requires too many inferences. We don't really know what happened to the injury on the chest. She extrapolated Dr. DeYoung's statement about the yellow scuff mark. I'm not willing to follow that same inference upon inference. I don't know what caused the injuries to the chest. I don't know what caused the injuries to the head, but he died as a combination of strangulation and blunt force trauma to the head. The doors to the house were locked, something that I didn't understand. The keys were found in the yard in the rear between the house and the garage area. Trash and a duffel bag believed to belong to the suspect were found by the church. Officer Herman testified the defendant had apparently been sleeping under a foyer roof at the church in November. So I don't know what that means, if anything. Defendant made multiple statements, some which may be admissible, some which may be ruled to be not admissible, but he didn't make much of an inculpatory statement. One of the things I wanted somebody to say is, what were you doing at 6 a.m. on a Thursday morning in the dark in Todd Swartz's garage? How did you come to find him in there? What were you doing? Why were you in there? Where did you come from? Where had you been? Who had you talked to? I don't know any of those things. I don't know if they were asked or not. The defendant was very difficult to communicate with, didn't seem to understand what was being asked, and his responses were often non-responsive. So I don't know what he was doing there at 7 a.m. at 6 a.m. on a Thursday morning in Todd Swartz's garage. If somebody asked him, nobody told me. His first statement says it was Todd Swartz. He had not seen, it had been a week since he has seen Todd. He is no longer staying there. He said, I didn't have anything to do with it. Well, first statement, by the car. Second statement is they put him in the front seat, and there's some conversation there. The third statement, I didn't have anything to do with it. Defendant's in the back seat of the car. Number 4, after Brinkert says, I don't know if he's out of his mind or just a dumbass, he comes back and starts to type the search warrant to search the house. Defendant said in this conversation, and it's arguably that he's in custody at this point, but he had not been Mirandized. This is the statement prosecution's resting much of their case on. And defendant opened the door, he said, he opened the door, saw Todd, stepped out, did not like what he saw, said he had not touched Todd, and he didn't know who would want to harm Todd or whether anybody was mad at him. It was in a very low tone and it was very hard to understand. So he says, I didn't go in there. That's important, is whether that's admissible or not. But I guess I'll take, for the sake of argument, this is the investigatory stage. But he wasn't free to go. He was put in the back of the car and the doors were locked. The windows were rolled up and he slid the panel over so somebody couldn't climb through like had been done to one of the officers here was involved in this, and they took off in their car and drove it in the river, and it was all bad. Anyway, he was in the back of that car, and nothing inculpatory except he said, I didn't go in there, I didn't like what I saw, and I never touched it. So, you know from the lab reports that the defendant has the decedent's blood on his clothing. And that's really it, what the case boils down to. The shoe swabs, I thought that the shoes on the bottom were, there wasn't much I could see on there, and apparently none they could see. There was a trace amount of blood where the lab technician took a swab and a little bit off the top and sides, but we couldn't really see what it was. They certainly were not drenched in blood, like he was stomping on the defendant or walked around there or put something under his head. There were traces of blood on his shoes. There was someone else's DNA also. His own DNA was not on his shoes, but the decedent's was on there, and someone we don't know. And as we know from the lab technician, Ms. Schmidt, we don't know if that's just some random DNA or whether it's related to the case. There's no way to know. I did learn that there's no way to submit that unknown evidence into CODIS for determination. There's blood on the pants. There's Ethan Dingman's DNA on his own pants. Todd Swartz's DNA on his pants. Again, they aren't blood soaked. They're traces of blood. Also, 2 other people have DNAs on defendant's pants. So who is that? We don't know. Was it the officer that took his pants off? And Officer Weesey, or Attorney Weesey, makes an argument at this point. It isn't clear that this stuff is even admissible. I'm considering it for purpose of this case, but his argument is they didn't have authority to make an arrest, and they seized this subsequent or subject to arrest. The prosecutor pointed out that somebody got a search warrant to seize these items. I don't know what was in the search warrant. I haven't seen them. So, although the glasses were removed from his pocket when they told him to empty his pockets when he was arguably in custody. But if he was in custody, they would have found it subject to arrest with the booking process. The glasses. I looked at them several times. We saw a picture of Todd Swartz. We saw a picture of the glasses. Many years ago, I think I was an intern, about 1980 here, a woman was assaulted badly in Three Rivers, and a workman was working outside her house, and he saw her, and he came back later and assaulted her. He lost his glasses, and they did an analysis of the glasses for a prescription to determine the prescription of the glasses, and they used that prescription to link the glasses to the suspect who was ultimately convicted. So if they could do that in 1980, they certainly could do it now. But I didn't hear any evidence about any sort of prescription analysis of these glasses, other than they're argued that they're Todd Swartz's glasses. They look like some glasses that Todd Swartz had on in a picture. I don't know if they are Todd Swartz's. Ethan Dingman wears glasses. I don't know if they were his glasses. But there were glasses found which are similar to glasses worn by the decedent. But I don't know if there's a prescription match or other evidence. And that evidence was troubling. It's probably the most a powerful piece of evidence for the state. Let's assume, if we're assuming, the defendant walked in more than he said, bent down, looked at the decedent, got the heck out of there, and stepped in some blood, and left. But why would he have the decedent's glasses? If he was asked anything about it, I don't know the answer to that. The forensic report with hearsay over hearsay says that he went to the Shell station and was in the bathroom for an extended length of time. And I don't know what that means. As I said, it was told by somebody who was told a police officer who told investigators, unknown, who put it in this report. They did investigate the Shell station. Officer Paul didn't remember whether he went to the scene or not, but apparently he did. That wasn't very good. He had actually been there, and Officer Paul applied Lyro Crystal Violet to the restroom at the Shell station. I think is something we used to call luminol, where you could see blood. A small area above the sink developed, indicating possible presence of blood. The area was tested with a hemostick with negative results for blood. So they didn't find any blood in the bathroom where the defendant was allegedly, for an extended period of time, cleaning himself up. Macbeth, out damn spot. It's hard to get rid of blood. So they didn't find any blood in the bathroom at the Shell station. And the defendant certainly wasn't blood soaked. Any blood they found appeared to be trace amounts. The shirts, there was some confusion. The shirt in the picture is apparently not the shirt with blood on it. And the shirt with blood on it isn't in evidence, and I'm not even sure whose shirt it was. So we've got the pants, the glasses, and the shoes with Todd Swartz's blood on it. The banana doesn't bear any weight. There's no evidence the defendant was ever in the house. That doesn't appear to be the crime scene. And nobody asked the people at the Shell station if he bought a banana, or I don't know, but the banana doesn't really, I think, have enough to bear into this. So when you boil it down to its essence, you have the defendant who was schizophrenic and later found to be acutely psychotic, but that morning I think his schizophrenia and mental illness was on display. He was not uncooperative. He called 911. I don't know what he said. He didn't leave. He didn't run away. He went next door and called 911. And then he stood there and he waited. The officer told him to stand by the car. On one hand, treating him as a voluntary statement. On the other hand, believing he's a suspect but not 110% sure. And he doesn't go anywhere. He's not uncooperative, he's just unresponsive and often incoherent. So we have a defendant who calls in the crime scene and waits for everyone to get there. I don't know what time he went in the Shell station or how long he was in there. All we know is that he made the call at 6:52 and he came out when the trooper pulled up in a blue state police car and said, "It's Todd Swartz and I didn't do it." And I don't know who did. The blood on the glasses is troubling. Again, I don't know whose glasses they are. I think there's a pretty good inference they belong to Todd Swartz. Where they came from, how they came to be in the defendant's possession, I don't know. How did blood get on there? I don't know. We know the evidence technician was handling bloody evidence not very carefully. We learned there was a blood-soaked sweatshirt somewhere that I didn't learn about until late in the game. And the officer didn't change his gloves or the paper he was laying the evidence on. I don't know if that blood-soaked sweatshirt was in the same place at the same time. I don't know. So I've been struggling with this for the entire tenure of this case, at least once it started. I've been looking for the there that's there. There may be a lot of other evidence that is available, but as I indicated, I'm only to consider the evidence that's admitted at the preliminary examination. As both Mr. Weesey and the prosecutor said, it doesn't matter, at least for bind-over purposes, whether there's other sources of DNA in these samples. It doesn't matter whether the defendant's footprints match or don't match the bloody footprints on the floor. As the prosecutor stated, those are issues for trier of fact. So all I do know is the defendant called it in, denied that he did it, denied that he went in the building and has some trace amounts of the decedent's blood on him. And I do not believe that's enough to bind the defendant over on this charge of open murder. And I don't do this lightly, Mr. Dingman. I don't know if you did this, or I don't know if you didn't do it. I don't even know if you know that. But there is certainly more evidence to be gathered, and maybe there's more evidence here than I know about. But I don't find that the evidence presented here is sufficient to bind you over on a charge of open murder. And I don't take this lightly. I gave the prosecutor another week because I didn't want to just open the jail door and have you walk out, but that's what's about to happen. Mrs. Dingman, my recommendation would be that you come to the St. Joseph County Jail to pick Ethan up. Here's the 8th. Mr. Dingman, the prosecutor does have a right to appeal this. It's subject to an abuse of discretion standard, which is hard to find. And I've been, as I said, as careful as I could be with this evidence. I find that a preliminary examination was held on this date, and it was found that probable cause does not exist. To bind the defendant over to circuit court. This does not mean that the case is over, Mr. Dingman. Jeopardy has not attached. If this was to be a trial and a witness is sworn to testify, they cannot try you for the same offense. You've not been tried. You've been subject to a preliminary examination. And I found that there is not sufficient probable cause. If they can develop probable cause, you could be rearrested. I don't know where the state of this investigation is. I said my fear is once you went to jail and the case went to the forensic center, the investigation stopped. I don't know that, but I know at this point I don't believe there's sufficient evidence. So the defendant shall be released from the St. Joseph County Jail. Now let me say something else, Ethan. You didn't just magically get cured from your mental illness. There was a long struggle regarding your competency, and there was a greatly disputed hearing whether you're even competent. Competency goes to your state of mind right now. There's also an issue of criminal responsibility. What was the defendant's state of mind at the time of the offense? You need continuing mental health treatment. My strong suggestion is that you immediately contact community mental health for continued treatment. You're giving me the thumbs up, and I'm glad to see that. Because you're not just going to be cured when they unlock that door. You're going to be struggling. And I guess I have nothing more to say about that. I don't do this lightly. All right, the court has found there is not sufficient probable cause to bind this matter over at this time. Investigators are certainly encouraged to continue to investigate if it can be developed as to this suspect or another. This court or another court, probably Judge Pattison would hear any subsequent hearing. But I've signed the order that says examination was held and probable cause does not exist to bind the defendant over on the charge. All right.